Hello viewers, welcome back to the channel. So today we will continue our last session on law of real estate. Uh, in this lecture we will continue our rent control laws. In this lecture we will see the sections which are very important for your IBBI exam. Also, this will cover your IBBI syllabus, which is protection against eviction of tenants and then its effect on value of property. Okay, so please be with me. This is the part 2 of rent control laws. I will create one more video on this rent control law. After this, this act will be covered thoroughly. So please be with me. Our last lecture was a great success. After that, I have decided to make this video more useful to the valuers, because most of the viewers are valuer only and they are practicing as a valuer. So today's topic of discussion is standard rent fixation. Standard rent fixation in various states. First we will see one standard case, then we will see some Delhi and Gujarat and Maharashtra, how the Rent Control Act decide standard rent there. Sorry, section related to recovery of possession, eviction of tenant. We will see how a landlord can evict his tenant and under which section or under which grounds he can claim his property back. And after that we will see section 56, charging premium. In some places they say it Pagree. So is it legal or is it illegal? We will also see some more sections of this this rent control act. So first we will see section 8.1. Before watching this video, I will recommend you to watch my previous lecture on Rent Control Act, so you will understand it very easily. Okay, what section 8.1 says? It says about standard rent. So court may, upon an application made to it for the purpose, fix the standard rent at such amount as, having regard to the provision of this act and the circumstances of the case, the court deems just. Okay, in simple words, if you are a landlord or a tenant and you go to court and say that the market rate is very low, if you are a landlord, or if you are a tenant, you can say that market rent is too high, I cannot afford it, or it is not justice with me, landlord is charging too much. He can go to court and court can fix a rent. That rent is called standard rent. Okay, so there is no method. I will tell you that there is no methodology involved. The court will decide on the basis of merits and demerits presented by the landlord and the tenant. Okay, so what slide says you can read, but in simple word, this is the section 8.1. Okay, the language is difficult for engineers because it is written in the language of law. So I am teaching you in simple word and you can read the slides also and I will help you in that. Dispute between landlord and tenant in respect of permitted increase in the rent is also fixed by the code under this section, as I have discussed. It is seen that this section does not lay down any methodology. I have told you, for fixation of a standard rent, it is entirely left to the discretion of the court, who will decide on the basis of evidence of expert and submission of the parties concerned about the methodology for arriving at the standard rent of the rented premises. Okay, the court will decide which section gives the power? Section 8(1) gives the power to the court to fix the rent, and this rent is called standard rent. Now we will see the standard rent in Tamil Nadu, and after Tamil Nadu we will see Delhi. As I have told you that Rent Control Act was made by the state governments, so every state, or I should say each state, has its own law, okay, regarding the rent control. The name may be differ, but they have their own law. So in Tamil Nadu, what section 4 says? The section 4 says, the name of the act is written here, the Tamil Nadu Building Lease and Rent Control Act 1960. Fair rent, which is called standard rent, for any residential building, this is for a residential building, shall be 9% of gross return per year on the total cost of such building. So this is on the basis of cost of the building, and you cannot charge on beyond 9%. So this is fixed by the Tamil Nadu state government. Fair rent on non-residential buildings shall be 12%. So for commercial properties it is 12%, for residential it is 9%. Gross return per year on total cost of such building. Total cost of building shall consist of market value of the site, I mean land, the cost of construction of the building, and cost of amenities as on the date of application for fixation of fair rent. So in simple, what it says that while analyzing the 12%, this 12%, you have to calculate the market value of land, you have to add the construction cost of building and the cost of amenities. After that you can calculate the 12% for commercial and 9% for residential building. This is section 4 says of Tamil Nadu lease and rent control act. Okay, so this is for Tamil Nadu. For Delhi, what they say? For Delhi Rent Control Act 1995, reenacted in 1995 but not yet implemented. So in Delhi, as per my knowledge, that it is not implemented. If you are from Delhi, you can comment it is implemented or not, but in your textbooks it is written there. Also adopt this investment basis. So this case, why this is important? Because it talks about a case law which is in your syllabus. So what this law will, I will tell you. Section 7(1) of said act provides that the standard rent of rental premises should be calculated at 10% of the cost of land and building construction or improvements. Okay, so here in Delhi it is 10%. Okay, but the Bombay court also accepts the investment basis. Okay, when we will study the case laws, we will talk about a case of Saurabh Talati versus Joseph Mitham. So this case law talks about investment theory. What investment theory is, we will deal separately in case laws videos, but here you can remember this name. This name is very important. So here the court proposed a theory, investment theory, on the basis of which you can calculate the standard rent. You can, I mean to say, the court can decide the standard rent. Okay, so the rate of return is, however, is not fixed in the Maharashtra Rent Control Act as it is as in other states, and it is left to the courts to fix fair rent of return depending upon the date of letting and prevalent circumstances at the said relevant period of time. Okay, so in Delhi there is this act is not implemented, and in Maharashtra there is no rate of return is fixed by the court, and the court will decide on the time of the hearing what will be the standard rent. Okay, so the rent fixed by the court is called standard rent. You have to remember this. You don't have to mock up these sections thoroughly. You just have to understand these sections. Okay, so this was the standard rent. Now we are moving towards section 10. What it says, let's read. These sections are important. That's why I'm talking about these sections only. It shall not be lawful for landlord to claim or receive on account on rent for any premises any increase above standard rent. This is however subject to 11(1) provision, which is permissible. Okay, so the landlord cannot say that I need this much money on standard rent, okay, on and above standard rent. So once the court decides the standard rent, it actually take all the factors into consideration, and the landlord is not allowed to take any other charges from the tenants. Okay, but there is a provision in this section. It is called section 11(1). It permits some year to year basis increase in the rent. So we will see section 11(1) in our next slide. This is the permitted increase, section 11(1). So annual increase in basic rent, it is also called standard rent, after commencement of act 31st of March 2000, a landlord shall be entitled to make an increase of 4% per year in the rent of premises let for any purpose. Okay, so as per section 11(1), an increase of 4% is allowed as per law. Okay, uh, uh, after the we will see some more clauses about the increase which is allowed in this act. It is also called Pagree in the last of our lecture. Please do not confuse with section 11(1). It only talks about the annual increase and any other premium. Okay. What section 14(1) says, it talks about repairs. So every landlord shall be bound to keep premises in good and tenantable repair condition. So it is the duty of landlord that it makes the premises habitual, so it can be tenanted. Section 14(1) bounds that in the tenanted building as in disrepair condition. So suppose a building is there who is not in the condition so that it can be let out. While estimating the value of rental method, the valuer should deduct, please keep in mind, the valuer should deduct cost of repairs to put the premises in tenantable condition. So when you will do practice, you have to deduct the cost of repair first, then you can analyze the rental value. Okay, क्योंकि जब तक आप बिल्डिंग को रिपेयर नहीं करोगे आप उसमें रह नहीं सकते. Okay, so this is the reason. I hope section 14(1) is clear to you. Let's move to section 15(1). Section 15(1) talks about possession. A landlord shall not be entitled to the recovery of possession of any premises so long as the tenant pays or is ready to and willing to pay the amount of the standard rent and permitted increases. Okay, so if the tenant is ready to pay the rent, he is ready to pay the permissible increase, and he is also not committing any unlawful act, the landlord cannot evict the tenant from the premises. Thus tenant cannot be ordinarily evicted if he pays frozen rent regularly. Okay, so this was the problem of Rent Control Act. This clause, this section was the problem. The landlord was helpless. He was not able to evict the tenant without the permission of tenant itself. So it was the safeguard for the tenants. Okay, so in our next slide, I will teach you section 16. This section talks about the eviction of tenants or recovery of possession. How landlord can get his premises back. I have deliberately made these section in red color so that you can understand it better. What I have done, I have summarized this section and put all these sections together which talks about eviction. So when you will see there is A, B, C, D, E, F and till J. These sections are talking about eviction of tenants. Okay, I have done some work for you so that you don't have to look separate sections. So these sections talks about eviction of tenant. Okay, and these sections are very important. When you will practice, you will understand how important these sections are. Many landlords are facing challenges. They are not able to evict the tenant. So these sections provides the ground on which you can evict the tenants. Landlord can recover possession on the of the premises in the following situations. What are the situations? First is the section 16(1)(a). This is the ground of eviction. Tenant commits act contrary to clause O of section 108 of Transfer of Property Act 1882. I will teach you this act, Transfer of Property Act. This act is in your syllabus. So for now, you just remember the clause and the name of the act. Do not worry about what this act is. What this section says, I have written here. So let me read it out again. Tenant commits contrary to clause O of section 10 of Transfer of Property Act 1882, which says carry out alteration which causes damage to the building and is permanently injurious to premises. If tenant is doing any construction activity or any other activity which is causing harm to the building, or it is creating some damage to the structure of the building, so the landlord can go to the court and say I do not want to give the premises on the rent. So court can order and you can get your possession back. So this is the one ground. What other section 16(1)(b) says? So what it says, tenant has erected any permanent structure or premises without permission from the landlord. So if tenant does not have the written consent of the landlord and the tenant creates a permanent structure on the land or in the building, so landlord can go to the court and ask the eviction of the tenant. So section 16(1) also the ground. Then 16(1)(e), tenant has after 1st February 1973 sublet or given on license whose or whole or part of the let out premises. So the tenant cannot sublet the premises without the written consent of the landowner or the landlord. And in case of license also, he cannot sublet the premises because license is not transferable. When I will teach you the license part or in our license or we can say there is another section which talks about license separately. We will talk license there. For now, you can understand that license is not transferable. So the tenant cannot transfer his license. So this is also the ground. Another is section 16(1)(g), on the basis of which you can ask for the eviction of tenant. Let out premises are reasonably and bona fide required by the landlord for personal use. If landlord want to use the premises for personal use for some reason, for some lawful reason, he can go to the court and ask for eviction, obviously. Then section 16(1)(1), let out premises are reasonably and bona fide required by the landlord for demolishing for the purpose of erecting new building. Okay, so if the landlord is creating a new building, he can go to the court and he can uh, evict the tenant and he can get the possession back. And another section is 16(1)(n). This talks about let out premises have not been used for a continuous period of 6 months prior to the date of suit. Okay, so when you file case and your premises was vacant for more than 6 months and this 6 months is continuous, so you can go to the court and say that I want my possession back. A study of these provisions will enable a valuer to decide as how many tenants in the building can be evicted for breach of these provisions. So as a valuer you should know these provisions, so you can analyze that either the landlord can get the possession back or not. Okay, so in your practice this section will help you. Please keep in mind. Another section is section G, section 16(6), C and D. These sections are for court. A court can also evict the tenant. So what it says, let's see. Provides for circumstances under which court may pass decree of possession for reconstruction of old let out premises. Okay. New building to be erected by the landlord containing residential tenants not less than the number of existing tenants sought to be demolished. Okay, so when the landlord will erect a new building, he have to accommodate these tenants. Okay, second point, what it says, plans for a new building include new premises for such tenants with carpet area equivalent to the area of old premises in his occupation with variation of 5% in area. Okay, first condition was the number of tenant. This first point was talking about number of tenant. The second point is talking about carpet area. Okay, you cannot give a tenant less than what he has in his possession, plus minus 5%. This variation is permitted, and landlord has adequate money for new construction. ऐसा नहीं हो सकता कि लैंडलॉर्ड के पास मनी नहीं है और वो कोर्ट से कहे कि मुझे नई बिल्डिंग कंस्ट्रक्ट करनी है. So these 3 points can also be the point under which the tenant can be evicted. These provisions would enable a valuer to estimate with fair degree of accuracy land values under redevelopment projects by estimating rehousing cost for existing and sitting tenant in an old building. Okay, so when there will be a redevelopment project, you have to think about the old tenant. What is the status of old tenant? What you have to give to the old tenants before computing the value of new building or new developed building. Okay, so this is very crucial. Please remember these sections. This will make your practice better. So you don't have to mock up this section. The exam is not asked you to write this section as it is, but you have to remember which section says what. Okay, another section is section H, section 20A, point number H. In case of court decree for eviction for reconstruction, in the case of reconstruction we are talking, the tenant shall give notice to the landlord of his intention to occupy a tenant in the new building on condition that he shall pay the standard rent in respect to the tenement in the new building. Okay, so we have to give the notice also. Okay, and the notice is also important. Under section 20A we have to give the notice. This provision would also enable a valuer to fairly estimate the rental value of premises in a new building. Okay, when you will move to the new building, the standard rent which is allowed you will get. So what you are getting after constructing a new building and if you have sitting tenants, you have to calculate the standard rent and then you have to give the value. This provision would also enable a value to fully estimate the rental values of the premises in a new building under redevelopment project for valuation of the property to be valued or to estimate fair market value of the land to be purchased by the residual method. Okay, we will study these methods. What are the residual method? Okay, but for now, you just remember that in the case of reconstruction, you have to make arrangement for sitting tenants also. Okay, so this was the section H, point number H. Now point number I, section 24(1). A licensee in possession of premises on license for residence shall deliver possession of such premises to the landlord on expiry of the period of license. So license is not transferable, and after the expiry of license, you can ask the tenant to leave. Okay, and on failure of the license, to so deliver the possession of licensed premises, a landlord shall be entitled to recover possession by making application to the competent authority. Okay, so license is not transferable. So if you are giving your land to someone else, or you are giving your building on rent, you must create a license, because license is valid under law, and it also says under section 24(1) itself that after the expiry of license, the tenant has to vacate the property and you can get the market value after the license period. Okay, so people do not know about these laws and they fear about Rent Control Act. Okay, another section is section 24(2). Any licensee who does not deliver the possession to landlord on expiry of license period and continues possession shall be liable to pay damages at double the rate of the license fee fixed under the agreement of license. So what happens when you create a license, you fix a fees, and on the basis of that license, the licensee pays you the fees. When we will read the Contract Act of India, we will read about license and licensee and how many type of agreements are there. There we will learn that license is not transferable, and when the license is not transferable, this is better. If you are giving your premises to someone on rent, please create a license, because section 24(2) clearly says that if the licensee is not giving the possession back on the expiry of this license period, he has to give double the rate of the license fee fixed under the agreement, which is fixed by you, till he vacates the premises, for which the maximum period is 6 months. Okay, maximum what he can say, he can live 6 months more than the license, and for this 6 months you are getting your double license fee. Okay, so people do not about these laws, and what section 24(2) says, this provision would enhance the value of the property given on lease and license, as rental value is not frozen and eviction is assured. However, this provision is applicable for commercial and industrial premises given on leave and license. Okay, so this section 24(2) is not applicable for commercial properties. This point is very important. Do not think that section 24(2) covers commercial and industrial premises. It only covers residential premises. So you can give your residential premises on live and lease license, and you will get your property back. Okay, please, valuer, in your practice also, please keep these sections in mind, so they will make you very knowledgeable. For the IBBI exam point of view, these sections will not be asked directly that write these sections. If you remember what section says what, your work is done. Do not mock up these sections. Okay. Some more sections I have mentioning here. Section 26, it shall not be lawful for any tenant to sublet or give on license the whole or any part of the premises let to him. Okay. Section 26 restrict any tenant to sublet. Okay. Section 31, a landlord shall not use or permit to be used for a commercial purpose any premises which were used for a residential purpose. So what is happening nowadays, people give false information to the municipality or nagarpalika or nagar nigam that my premises is residential, and they give the premises on rent for commercial purpose. And what happens when they claim the agreement, the rent agreement becomes void on the ground of section 31. Okay, because 31 do not permit any landlord to give any residential premises on commercial purpose. You cannot give a residential premises to a commercial institution or commercial purpose. So please keep this section also in mind. Okay, so your contract will be declared void. When we will study contract, we will see these terms also. So now let's move on. Section 55(1), any agreement for leave and license or letting of any premises with effect from 31st March 2000 shall be in writing and shall be registered under the Registration Act 1908. Okay, so if you are creating any license or any tenancy, you have to register it in the Registration Act 1908. Responsibility of the registration shall be on landlord. So landlord has the responsibility. This section puts responsibility on the shoulder of landlord only. So do not think that that it will affect the tenant. It will affect the landlord only. Okay, the penalty will be levied on the landlord only. Okay, so this section 56 talks about charging premium. I was talking about this section when I was talking about Pagree. So Pagree is now legal. Okay, how? I will talk about that for about 5 minutes. Just read this slide. I am not saying you to remember the slide. Just read the slide to understand what happened, why Pagree is legal now. Okay, I am reading it for you. The first point says, it shall be lawful for the tenant to claim or receive any sum or any consideration as a condition of the relinquishment, transfer or assignment of tenancy of any premises. If your agreement or if your tenancy document permits you that you can sublet the premises, then you can also entitled to get any profit from that premises if you sublet the property. Okay, if you are receiving any extra rent, suppose you get a premises for 10,000 rupees on rent and you sublet it on 20,000. So the profit which you are making of 10,000, you are entitled to get that premium. You don't have to give that consideration to the landlord. Okay, if it is not written in your agreement, if it is written that you have to share then it is you're bound to share. Okay, but it allows. Okay, in general condition, it shall be lawful for the landlord to receive any fine, premium or other like sum or deposit or any other consideration in respect of grant or renewal of lease of any premises or for leave or for giving consent to the transfer of lease to any other person. Okay, so this point number 2 talks about the landlord. So if landlord is receiving any fine, suppose if a tenant creates some unlawful suppose any nuisance in our premises, you can charge them a fine and you can keep that. You can also charge a premium, or you can charge Pagree according to this point, section 56(2). Okay, so Pagree is now legal according to this section. So I have written all the history behind the Pagree is here. So I am reading it. This is a very vital provision or amendment in Rent Act as per section 18(1) of 1947. So we are talking about this 1947 Act with amendments of 1987. So amendment was there in 1987. Now the amendment got repealed. Any landlord receiving premium or other like sum or any consideration other than standard rent from tenant was punishable with 6 month imprisonment. Now under section 56(2) of 1999 Act, such recipient of sum by landlord is made legal. Okay, I have taught you a section earlier that excess of standard rent is not permitted, but now in section 56(2) they are allowing landlord to take the fine, premium and any sum or any deposit which is called Pagree here in some places. So these are allowed under section 56(2) of 1999 Act. Okay, so you can refer it. Then up to 30th March 2000, accepting premium was criminal offense, but on and after 31st March 2000, acceptance of Pagree is legal and is not an offense. Okay, I have made clear here. This acceptance of government's failure to control market forces by introducing rent control legislation for long period, that is by arbitrarily controlling rent for long time period, is important. Okay, so this act was important. The government seems to have now recognized power of market forces after 60 years. So in 60 years they have realized their mistakes, and this provision however may have effect on valuation of rented property only to some extent, since the protection of tenants for the eviction and provision of control act is still continue even under 99. Okay, so the rent control act is now not very much like in news, because the government knows that we cannot put market forces on hold for a long time. So that's all. I know this video is very lengthy. This is the last slide. Please be with me for some 5 minutes. That's all I need. Up till now, occupancy right had no value in law, but now it will have some value in the time of creation of new tenancy, as well as at the time of transfer of tenancy, since charging of sum by tenant while vacating the premises and demanding premium by landlord while letting the premises have been legalized. Okay, so what was happening before 56 sec 2, the landlord was not able to get any excess amount on standard rent. He was getting only standard rent, so the rent was freezed, so the value of the property was decreasing, so it was not good for our economy. So what government has allowed, and they have allowed landlord to charge a fee or a premium when we transfer the tenancy. Suppose I change the tenant, so I can charge another market rent to the tenant, and if I want, I can charge the premium which the tenant is getting after he sublet the property. Okay, I can demand the share. So it must be remembered that in spite of legislating the premium money Pagree for the occupancy right, this right is not freely transferable or assignable in the market like ownership premises. So Pagree is legal, but it is not transferable as ownership. It is subjected to landlord's bill and tenant's willingness. Okay, if landlord want, he will allow tenant to transfer his Pagree, or he can deny. Okay, he has the right to deny. Landlord can deny that I do not want any excess charge, or I do not want any share from the premium, and I am not allowing you to transfer the Pagree. Okay, unless either party enters into written and registered contract for transfer of tenancies to prescribe new, to prospective new tenant, this occupancy right has no value in the open market. Okay, if you do not have a written consent or written agreement, and then you cannot transfer. Okay, and it has no value in the market. But if you have lease and you have a written clause there, you can transfer the lease, you can value that, it will fetch some value in the market. Landlord has a right to reject or refuse transfer of tenancies even if offered considerable amount as premium or pagree. Hence, tenants' occupancy right is not marketable, right? It has only value in use and no value in exchange. Please remember, this last line is very important, that tenancy right is a right which has value in use and no value in exchange. Okay, but lease is a different case, it has a written permission. Okay, so that's all. Thank you for watching this lecture. If you are watching till now, you have a good patience. So I will create a part 3 for Rent Control Act, and then we will finish this unit. I hope you have understood the sections. I have tried to make them simple, and please keep supporting, because this is not an entertainment channel. I am at your will. Please, if you will not support, I will not able to make more such content, because I am putting lots of effort here, and I do not get time usually. So if you will not support, I will not be able to make videos. Please subscribe and leave a comment if you have any doubt or suggestion for me. I will try to improve. Thank you.